Okay, welcome back. We're still in Chapter 5 of the Law of Journalism and Mass Communication text dealing with libel and defense and privileges. So far in the chapter outline, we have covered truth, and we've done a quick revisit on libel law. Now we're going to get into anti-SLAPP protection. So SLAPP. What the heck is SLAPP? SLAPP is an acronym. It's for lawsuits that are used in a way to harass critics. It stands for strategic lawsuits against public participation. Again, it's just a clever way of saying filing lawsuits to harass critics into silence. Goal with it is suppression, and just filing of the lawsuit has a chilling effect even if there isn't any real merit to the case. And plaintiffs rarely win these cases, but they use them as an intimidation tactic or as a strategy. And sometimes they'll use it to get the names of people who are anonymous. So they go far enough into the lawsuit where they get to discovery, and they show the need to get that information, and they get the names divulged. Causes of action. So the actual causes of action in these types of lawsuits: defamation, you get interference claims, you get conspiracy, you get intentional infliction of emotional distress, and negligent infliction of emotional distress. So again, defamation, libel and slander, impacting on somebody's reputation, interference with contract or economic advantage, or tortious interference with business relations. This all goes towards some sort of economic benefit that the plaintiff was supposed to get, and that was denied to them. Conspiracy is where people are working together to commit some illegal act, such as conspiring to commit libel or interfere with a contract. And we talked before about intentional infliction of emotional distress. Negligent infliction of emotional distress can also be categorized as one of these SLAPP lawsuits. So SLAPP laws, this is just a way of categorizing them. This is not an official legal term that is codified, so you wouldn't do legal research and go to the SLAPP laws. These are lawsuits that are nicknamed this way so that way their use or abuse has a label. So again, strategic lawsuits against public participation. It's weaponizing lawsuits to stop critics. Plaintiffs, when they're filing these lawsuits, their goal is to stop the critics or stop these statements with the claims that there's an injury. So sometimes they'll request injunctive relief. Courts will make the plaintiff try to prove their case at the outset. So when the complaint is filed with the court and there's a request for that preliminary injunction, the standard is success on the merits, where the plaintiff has to be able to convince the court that they will probably win the case. Many jurisdictions actually have laws in place that protect against these types of lawsuits. They're called anti-SLAPP laws. 31 states, plus the District of Columbia and Guam, all have enacted anti-SLAPP statutes, and their courts will recognize anti-SLAPP protections as a matter of case law. So that's in the state courts where these protections are in place. In the federal courts, it depends on which circuit the case is brought in. So in the 1st, 5th, 9th, and D.C. circuits, they have actually been enforced. In the 11th Circuit, they've rejected SLAPP acts. Those are state laws that are put in place that can be enforced in the federal courts. Essentially what these anti-SLAPP laws do is they raise the burden of proof on the plaintiff to show that they would prevail in a case at the very beginning, before they'd be able to do discovery and before they'd be able to move to the later parts of the trial process. That has the potential of resolving a dispute at the outset and possibly saving all the parties and the court a lot of time. Alright, so that gets us through anti-SLAPP, and we'll move on to the next one.